Hi, it's me Vivek Takal. My student ID is EMB24423. Today we have present the group presentation, provide the case study regarding the Corporation Act 2001. Furthermore, I would like to mention that the different part of the topic will cover by our different member of the group. Case study on Corporation Act 2001. Introduction. The Corporation Act 2001 is the principal legislation regulating companies in Australia. It regulates matters such as the formation and operation of companies, duties of officers, takeovers, and fundraising. Now, the Corporation Act will be further described by my friend.
Hi, it's me Yashoda. My student ID is EMV24348. Now I'm gonna discuss about the Corporation Act Section 9. As member is defined in Section 9 of Corporation Act 2001. As per the mentioned section, a member in the context of the investment scheme means a person who holds an interest in such scheme, or in the context of a company member, a person who is member under section 231 of the Act. Member can be a person or a body. Corporation Act. The Act does not specify the bare minimum age of a person to become a member of the company, but the company can very well determine in the article regarding the minimum age criteria of a person wanting to be a member. However, there is no member in the company than the owner and the secretaries and investment commissions may be to wind up the organization to form. The shareholders are basically the owners of the company. The company has a different legal entity of its own other than those of its shareholder. As the shareholder are basically the owner of the company has different legal entity of its own than those of its shareholder. It has the power of resolution for taking the decisions related to the company. Shareholders are often refers as member of the company. But when the shareholder sells or transfer their shareholders in a company, but a member remains a member till the time his or her name has been removed from the register of member of the organization. By the case study James Burden on becoming a member of the company Saturday night, since the notice has been mailed to him electronically, which is a valid form of sending a notice under section 249J of the Act. Now my friend's gonna describe about the further topic.
Under the Section 120 of Corporation Act, the member is to be listed and must have been given before the registration process, as well as all the person, their name, and their address should be written in registration application. After becoming the member of the company, which is registered in ASIC, which means Australian Securities and Investment Commission, and after becoming the member, the related person is responsible for the change made to register to the member of Australian Securities and Investment Commission.
I'm Sarita Low. My student ID is EMP24349. Further, I'm going to continue the eligibility criteria of a member of a company. He can either be a person subscribing to the securities of the company or his name is to be mentioned in the register of the member. Similarly, a body corporate can be a member as well. The shares subscribed by the members as mentioned in the application are required to be issued to them on the date of registration of the company. The name of the member is to be recorded in the register after allotment. As per section 114, at least one member should be there in a company as a minimum requirement. In case of proprietary companies, the number of members must not exceed 50 members and they should not be associated with the employees. And while advising, James Borden can cease to become a member of the company in the following circumstances. If the person sells all his shareholding in the company and the registration have been transferred to another person. Or another possible reason can be when the company buy back all the shares. Or cancellation of the registration of company by ASIC also sees the membership of a company. Furthermore, the remaining topic will be covered by my friend Vijay.
Thanks to my friend Sarita to giving me this opportunity. Hi, it's me Bijay Yadav, holding the student ID OED2988. I am going to discuss the case where the chairman is absent in the annual general meeting. In the absence of the chairman, the board of directors first refers to the constitutions of the company and board chart to know the rule how to elect the new chairman. If in the constitutions or in the chart board there is no such provision, the chairman of the annual general meeting must be appointed by director or member presented at the meeting. If no member are liable or able for that position, then the meeting should be postponed for the next day. Furthermore, the other topic will be discussed by my friend.
Hello, I am Vivek Raj, holding student ID EMV24488. Thanks to my friend for passing on the topic to me. In addition to whatever he said earlier, I would like to add that Section 1322 of the Corporation Act 2001, which deals with the irregularity in proceedings under the Act. As per Section 1322, subsection 1 of the Act, a proceeding which also includes the annual general meeting carried out under the Act cannot be said to be invalid merely because of any procedural irregularity in the proceeding, unless the court declares that the irregularity or the proceeding is detrimental to the interest of the shareholders and which the court cannot rectify. And the court also, by its order, then declared such proceeding to be invalid if uh, if the company fails to fulfill the quorum during the AGM, or that also happens due to the defective issuance of the notice for the meeting. And section 1322 also add that which also deals with the irregularities in the proceedings. The provision says that a particular proceeding under the act is considered irregular if the quorum is not present at the meeting of the corporation or at the meeting of directors or creditors or joint meetings of shareholders and creditors of the organization. There is any irregularity or defect in the issue of the meeting, which is issued to the members of the company. Having been said, the irregularity in proceeding are affected by all these matters, all these factors. And concluding the same thing, I would like to pass on the topic to my friend.
Thank you again. Continuing the topic, as we can see, the company CFO Alan has the tender for the renovation of SNL. Alan cousin has the renovation business, and in this contract, Alan pass the confidential information to his cousin, and finally his cousin able to get the contract for the renovation of the SNL. So after looking this scenario, this is an appropriate case of conflict of interest of a director or office of the company. Furthermore, I would like to pass to my friend.
Thank you for passing the topic to me again. So, continuing the same topic, there are four different sections that deals with the contravention of the act. There are four sections which are section 180, 181, 182 and 183 that deals with the contravention of this act of Corporation Act 2001. Section 180 that deals with the exercise of care and diligence by the director or the officer. Section 180 that says that a director or the officer of a company should exercise their duties and power with utmost care and diligence at the time of discharging their responsibilities. If the director or the officer fails to abide the law, such a violation would attract civil penalty and he or she shall be punishable under section 131 7E of the Act. Whereas section 181 that deals with the action of the director or the officer in good faith. Section 181 of the Act says that a director or the officer of the company should exercise their duties and power in good faith, which is in the interest of the organization. They should avoid any influence of his interest coming in the way while performing his duty for the company, and it should not be in detriment to any of the effect or interest of the shareholder. If the director or the officer fails to abide the law, such violation would attract civil penalty, and he or she shall be punishable under the section 131 7E of the Act. Continuing the same, section 182 deals with the use of the position by the director or the officer, where a director uses his power to get undue advantage out of his power, and also a director or the officer should not use his or his position which is in the interest of himself or herself or in the interest of any other person other than the organization, and which is detriment to the interest of the organization. Then he shall be or she shall be penalized under section 131 7E of the Act. Continuing the same, last but not the least, section 183 deals with the use of information by the director or the officer. The section of this Act says that if a director or the officer has obtained any information about the organization, and such information is passed only because of his relationship with the organization, then that director of the or the officer should not use such information in the interest of himself or herself. And failing the same, or not abiding the law, or not following the section or the protocol under the section, shall result in his termination of relationship with the company, and such violation would attract civil penalty under section 131 7E of the Act. Further, to describe more on further topic, I would like to pass on this topic to my friend again. Well, passing on this topic to my friend, before passing that, I would like to summarize the whole thing in a nutshell. The summary of the section is that section 180 that tells that the director or the officer of the organization should exercise their power and discharge their duties with utmost care and diligence. Whereas section 181, 82 and 83 says the director should follow and should be responsible for whatever he does. And accordingly, section 181 says that the director or officer of the organization must undertake any action in good faith which is in the best interest of the organization and which should not affect the whole interest of the organization and the member of the company. Section 182 that says that the director or the officer should not use their position for the benefit for themselves or for any person other than the organization. Last but not the least, section 183 in a nutshell says that an officer must not use the information obtained because of the position in the organization for the benefit of themselves or any other person other than the organization. I would like to summarize in a sentence that a director acting in his position should not use his position for the undue advantage that could benefit him but not the company. And having been said, I would like to pass on this topic to my friend for further more clarification.
Thank you again. In addition, a person must make declaration of controversy if section 1317E of the Act says that the court is satisfied of controversy. Controversy is also can penalize any person. The penalty is up to $200,000 in case of violation of provision. Lastly, I would like to call my friend for the conclusion. Thank you.
In conclusion, as per various provisions mentioned in the whole segment, any person who takes undue advantage of the information and position of the company, which is improper and related person, is personally penalized under civil procedure. Lastly, there should not be any proven guilt due to undisclosure of interest, and the relevant section also imposes penalty of $200,000 if proven guilty, which also disqualify company from registration. And thanking all of my friends for making this possible in this hard time. Thank you.